Log on, tune in, find out. Another good idea from Cambridge.
Very great pleasure this afternoon to introduce Saga, who's going to speak to us on the Pitcairn trial Saga, Justice in Britain's Smallest Colony. Saga has a long distinguished legal career. He was in practice at the bar in New Zealand and then was a High Court judge for 20 years until his retirement in 1997. Since then, Saga has been an arbitrator performing his arbitration functions nationally and internationally, and has also been developing a sort of sideline as a judge in various courts around the Pacific, sitting in the Court of Appeal in a number of important cases, including the Fiji coup case, and it was in that role that he was made one of the judges that dealt with the Pitcairn Islands case, one of the most interesting pieces of criminal investigation I think that I've ever heard about. He has also a significant academic background. For 8 years, from 1991 to 1999, he was the Chancellor of the University of Auckland in New Zealand, and part of his role there was chairing the university's governing body, but he also had to do the really difficult bit of conferring views on people. In that capacity, he tells us that in the 8 years, he reckons he shook about 32,000 hands, which is quite an impressive tally. But he's not going to be talking about hands shaking this evening. He's going to talk for about 45 minutes on the Pitcairn trials, after which he's kindly said he'll be to answer questions. So, introduce Sir Locke.
Thank you, Professor Feldman, for those remarks. Good evening, ladies and gentlemen. I count myself fortunate to have had 3 careers, as has been mentioned, and in many ways the third career has been the most interesting because of its international dimensions, not only arbitrations, but also these 2 very interesting and difficult and unusual cases of the Pacific. First, the Fiji coup case, of which I spoke at the latter part of the centre last week, and the Pitcairn case, of which I was a member of the Pitcairn Court of Appeal, a unique judicial body. The Pitcairn case, which I'm going to talk about, was described by one of their lordships in the Privy Council as unique. It involves fascinating history, esoteric legal considerations, and human tragedy. It was described by another of their lordships as a case involving child sexual abuse on a grand scale. It also raises issues of the rule of law in a remote place and the responsibilities of the colonial power. So what I'm going to do in my time is to give you first a brief geography lesson, then a little history of Pitcairn, then a little history of legal developments, then the discovery of the sexual offending, the reaction of those in charge and the laying of charges, then the setting up from scratch of a whole legal infrastructure, then listing the various permutations of trials and appeals, and then finally deal with the legal arguments, which can be, fortunately, dealt with relatively briefly because all three courts, the trial court, the Supreme Court, the Court of Appeal, which was the court I was on, and the Privy Council all agreed on practically every aspect of the case. And there were very many aspects argued in all three courts at great length. Now, where is Pitcairn? It is roughly halfway between New Zealand and Chile, in the middle of the Pacific Ocean, about 3,000 miles in either direction to either country. It is about halfway and on the route of freighters flying between Auckland and Panama. It is 2.5 miles by 1 mile. 39% only is arable, but is fortunately fertile, so it grows good fruit and veg. There is no wharf, there's no airstrip. The only way you can get land is coming in or out on the longboat, which are specialised boats which meet even a freighter to hose to on the island, and people sort of clamber down the side of the freighter. If the weather's rough, which it frequently is, you have to jump and get taken into the arms of the longboat men who happen most of the time to be the six accused. We'll hear later. Otherwise, you can go from Tahiti, from the easternmost extremity of the Tahiti archipelago, 36 hours by chartered vessel in very, very rough seas. And that's how the judges and lawyers and the various media people do for the trials. There are only 49 people. The maximum population ever has 200. The economy is limited naturally, but it can be reasonably self-sufficient for food, and all supplies have to come in from the freighter and unloaded onto the longboats. It's Britain's smallest colony, and strangely enough, unlike other small colonies in Britain, it's not coveted by anybody else, not like the Falklands or Gibraltar, who other countries would like to have, but nobody's ever put their hand up and said, we want Pitcairn, it belongs to us. So in fact, the British Crown is lumbered with Pitcairn, but it's actually 4 islands: Pitcairn, Henderson, DC, and Oenio, 3 of which are uninhabited. Henderson Island is a wildlife sanctuary. It has been designated as such World Heritage. And I met at Wilson not long ago 2 scientists from Cambridge who had actually spent some time on Henderson Island gathering information on the flora there and the insects and other animal life, particularly snails and birds. And so one of the pipe dreams is that maybe there might be eco-tourism to Henderson Island. That's a long way off. Right, so that's where it is. I hope you've got some idea where it is. It's literally miles from anywhere. Brief history. It gets its name from Midshipman Pitcairn, who sighted it in 1767 on the HMS Swallow. So it goes down in history for giving its name to this little island. 1789, there was the mutiny on the Bounty. You probably read about this, or may even have seen the classic film Charles Lawton, etc. And the mutineers on the Bounty set Captain Bligh adrift. He somehow found his way back to England. But the 9 mutineers, accompanied by 13 Tahitian women, about 6 Tahitian men, arrived on Pitcairn, and one of their first acts was to burn the Bounty on the 23rd of January 1790. Bounty Day is still Pitcairn's national day. Bounty is still at the bottom of the sea. So the Pitcairners had children by the Tahitian women, but most of the mutineers were killed by Tahitian men. Only one called Adams survived, And thus, the various other people, other British mariners, called Nobbs, Buffett and Warren, all the others being almost all Christian, Fletcher Christian, the leader of the mutiny bounty, they arrived and they made some rudimentary laws. They created 3 offences. One was murder, for which the penalty was death. Another was theft, which the penalty was pay back 3 times. The other was fornication, for which the penalty was whipping of both parties and making them get married. So anyway, thus it was, these rudimentary laws. In 1838, the British vessel, the HMS Fly, arrived, and its captain, Elliot, went ashore and decided that they needed a few laws, so he wrote out some laws in beautiful copper plate, and I've seen the actual copy of the copper plate preserved in the Public Record Office, because we had, I'll tell you later, all these thousands and thousands of bits of paper of great historical importance. He swore in a magistrate, planted the flag on the island, and from that day they regarded the visit of the Fly as important in their culture and as marking Britain's first acknowledgement of interest in the island. They all removed to Norfolk Island, which is about 600 miles north of New Zealand, but administered by Australia in 1856. And they stayed there for 3 years until about a third of them said they wanted to go back to Pitcairn. And so the British government took them back to Pitcairn, and there they stayed, and that's the foundation of the modern community. Things sort of putted along in the rest of the 19th century. 1 or 2 interesting little bits. They had Queen Victoria, they sent messages of loyalty and love to Queen Victoria, and sent her a chest of drawers made of breadfruit tree wood, and she in turn sent them back a present, maybe an organ that she had got commissioned a sea captain to buy in San Francisco for £25, and so they sent her another big thank you letter. Another interesting thing is in 1986 or thereabouts, all the islanders converted from the Church of England to Seventh-day Adventism, mainly because the Americans sent Seventh-days and sent 2 pastors there who stayed for some time, converted to locals, and whereas the CME said maybe somebody living out again. But that's perhaps beside the point, because the next legal significant matter is the Pacific Order of Council in 1893, made under the British Settlements Act 1887, which applied to British colonies which were not colonies by cession or conquest. Colonies have to be either settled, ceded, or conquered, and Pitcairn was neither of the last 2. So this would on paper apply to Pitcairn, but only to those which didn't have their own legislature, what Pitcairn obviously didn't. This act was applied to the Pacific by an order of the Council in 1893, but it didn't include in its various latitudes and longitudes, didn't include Pitcairn. So what to do when in 1897 a Pitcairn called Harry Christian threw his lady friend and baby into the sea, and he was committing murder, and he was detained by the locals. But in the meantime, back at Whitehall, they said, well, what are we going to do about this? Okay, we'll just move the goalposts literally and include Pitcairn in this Order of the Council. The Order of the Council said that the High Commission of the Western Pacific, situated in Fiji, would have jurisdiction over all these territories. And thus it came about that somebody from the High Commission of the Western Pacific, Suva, arrived on Pitcairn, made himself a judge for the day, and immediately tried and convicted Harry Christian, sentenced him to death, put him on the same boat, took him back to Suva where he was hanged. This was 1898. So, although the process they went through all the motions for all Harry Christian didn't have anyone to speak for him, there was no opportunity for any defence he might have. But the importance of that is that seared into the Pitcairn psyche was the knowledge that serious crime would be punished. And they always had the example of Harry Christian to think about. Well, not much happened in the first half of the 20th century. The Island Court was there, which dealt with some 43 cases. And there was no call on the High Court of the Western Pacific to sue for anything serious. There was one case on somebody was charged with abortion, which was regarded as a serious crime, but for some reason they never went anywhere. So there was nothing, there were a few civil disputes about mainly the boundary dispute nature, and nothing happened until 1952. One of the first acts of the reign of Queen Elizabeth II was to do the Pitcairn Order in Council. The Pitcairn Order in Council created the Office of Governor of Pitcairn for the first time, who was to be the Governor of Fiji. And he had the right to make laws in the traditional formula for the peace, order and good government of Pitcairn. These are traditional, this is the traditional formula which was misused, for example, in Chagos Islanders case to get rid of the law of the island. It's another story which does impinge a bit on Pitcairn. So anyway, under this power of ordinance making, which is a very easy way of making laws, the government just writes them out and says, I make the law. There's no nonsense of two houses of parliament or anything like that. It's just the government writes the law, that's the ordinance, and that's it. It can be disallowed by the Secretary of State, and it has been. But anyway, in 1961, the government said that the Supreme Court of Fiji, which was the trial court of Fiji, would try all serious crimes in Pitcairn, and that the laws of England for the time being in force would apply in Pitcairn. That is, again, incorporation by reference, which is pretty sort of standard. For some technical reason, they did another order in council in 1970, mainly because Fiji had become independent. So they transferred the administration from Fiji to New Zealand, and the governor of Pitcairn became was the High Commissioner for the UK in New Zealand. And the 1970 ordinance, for the first time, created the Supreme Court of Pitcairn. This was a court without any judges. And it was said at the time, well, it might never have any judges because they're all such good people. They never going to have anything serious to decide how wrong that was. But the Supreme Court of Pitcairn Island was created. And it was said, unlike the 1952 ordinance, that the common law, the rules of equity, and all statutes of general application and force at the date of commencement shall be enforced in Pitcairn. So everything was transported. I mean, you could argue, of course, that the common law and the rules of equity came with the settlers because of the Lord Hawthorne case that once, in those days, once a British subject, always a British subject, and you could shrug off your British citizenship just by burning the Royal Naval vessel. But anyhow, that is the state of the law at the moment, and on which all this was founded, that the laws of England in force as of 1970 applied to Pitcairn. This, of course, included the Sexual Offences Act of 1956. It was held by the Supreme Court and upheld by both appeal courts that Pitcairn was a developed society where it was known that rape and indecent assault were serious crimes and would be punished. Evidence was given by various Pitcairners to that effect, and there had been discussions in the Island Council of laws relating to consensual sex with girls under the age of consent 1970, puffered along. There was no English police presence. There was a New Zealand school teacher who acted as government representative, but really was regarded as an outsider by the Islanders. There was this island magistrate, of course, who was related to everybody, as everybody else was. And the Duke of Edinburgh visited in the 1970s, and the usual royal addresses. They produced postage stamps, which is always a small industry for a tiny nation, and they had British passports. And some of them did leave and go to New Zealand or Australia, or on that island. Anyhow, the whole thing started to blow up in 1996 when officers of the Kent Constabulary visited Pitcairn. Why the Kent Constabulary, nobody quite knows, but they were asked by the Foreign Office to be with the policemen for Pitcairn. 2 officers visited, and as a result, an arrangement was made that a police officer would come every 2 years to stay for 3 months. And thus it was that a police officer called Gail Cox arrived at Pitcairn in 1997-1998, and this was noted by one of the law lords, her painstaking investigation under difficult circumstances revealed a history of very bad sexual offending against young girls, as young as 9 or 10. So the decision was made that these offences had to be prosecuted or visited with some sanction. There was discussion at some stage about possible amnesty or Truth and Reconciliation Commission. That was not thought viable, and also it was thought that this system of rape of young girls was so bad that it couldn't be subject of amnesty, and there was suggestion that it had been going on for many years. So a decision was made to prosecute, and the 6 men that were charged, about 1/3 of the adult male population. It was thought that this was the tip of the iceberg, and various commentaries showed was an indication that the colonial power hadn't really done its job properly by allowing this sort of thing to go on unmarked, unchecked for so many years. But the 6 charged were historic offences, some as long ago as 1969, and up until 1999. 6 were charged with numerous offences, all of the sexual nature of rape or indecent assault. And so the question was, once that decision was made, what do you do? How you don't have any structure to try these offences, and so how to go about it? So the accused were interviewed in 2000, and except one who did wish to be interviewed, and there was quite a time taken before they were actually charged, because what had to happen was a lot. The government had to pass a whole lot of ordinances which set up a justice system from scratch. So you just stop and think for a moment what that involves. Ordinances creating courts, creating prisons, creating parole, creating probation, victims' rights, all the rest of it. And one of the judges of the Supreme Court was 3 closely typed pages of ordinances which the government had to do. So the legal advisors to the government kept churning out these ordinances to set up a viable situation where people could be tried. Then, of course, you have to appoint judges. Well, because of the proximity to New Zealand and the fact that Pitcairn was administered from New Zealand, in fact, by Consul General in Auckland, somebody called the Pitcairn desk, and they arranged all the savings and the supplies and everything like that. So they turned to serving New Zealand district court judges two others and myself, to provide a court of appeal. And there was also a right of appeal with leave to the Privy Council, as there is for all colonies. There then had to be a lot of negotiation between the UK and New Zealand about the Pitcairn Trials Act, because it wasn't going to be possible to do everything in Pitcairn, such as pre-trial applications, appeals, etc., even though the trials were intended and were in fact held on the island. So the legal subterfuge was, or fiction was indulged in on the analogy of the Lockerbie case, whereby, as you will recall, a little part of Holland became a little part of Scotland. So in New Zealand, wherever the Pitcairn Court, be it the Supreme Court or the Court of Appeals, sat, then that was the Pitcairn and wasn't part of New Zealand. So when we sat, for example, at one stage in the High Court in Auckland, and the New Zealand coat of arms was veiled, we had the Pitcairn flag, the British flag, the British coat of arms, and we were called My Lord, whereas normally in New Zealand and Australia we were called Your Honour. So that was good for the ego. So anyhow, this act was very comprehensive. It was a result of a treaty between the two countries, and it dealt with all sorts of things such as extradition and the ability to have a New Zealand Pitcairn prisoner served sentence in New Zealand, and it's provided for the assistance to be given by New Zealand police, justice officials, etc. Of course, the interesting thing was that the British taxpayer picks up the tab, and so far the whole exercise has cost the British taxpayer millions, please to know. Anyhow, then once you've got the court set up, then you had to decide what do you do. You hadn't laid any charges against these people yet, because you didn't have a magistrate, you didn't have a court system. So no point to laying charges against them if you haven't got anywhere to process them. So they solemnly went up to the magistrate as an Auckland barrister, and the lawyers, all Auckland lawyers, all paid for by the government, the state prosecutor and the public defender, and they all had numerous sidekicks. They all went up to Pitcairn, solemnly went to the little courthouse on the island, and laid the charges, and they didn't have a preliminary hearing because they accepted that there were prima facie cases, and what we call was a hand-up brief with the magistrate made an order of committal. So they were all committed to trial of the Supreme Court in Pitcairn. Now, back in suburban Auckland, and the only free courtroom in the system, suburb about 10 miles south of Auckland called Papakura, the Pitcairn Supreme Court heard preliminary arguments. Basically, the argument that Britain had no right to try these people because they weren't really British citizens and Britain had no control over them. And they had the judicature ordinance setting up the Court of Appeal had given it jurisdiction to deal with pre-trial appeals. So when the Supreme Court rejected these arguments, the Court of Appeal in August 2004 heard these appeals, and I don't know the details because they're all the same in the three courts. I'm going to do that later. And they rejected those appeals. In the meantime, the trial, everyone was all set to go to Pitcairn. A huge logistical exercise because supplies had to be taken 5 to 6 weeks. You're never too sure when you could get out because not every day is it possible to land down the side of the ship on the long way because the seas are pretty rough. So they had to get huge supplies, plus everybody up there, including a lot of the media, because it was televised. The proceedings in New Zealand were televised direct to Pitcairn because they are able to get satellite now and do have the internet, dot PA the end, which they didn't used to have. So after the Court of Appeal's first group, the trials started on the own. Very difficult for everybody, accommodating. Fortunately, because it can hold 200, the island had enough houses, but some of them had to be done made habitable. The 3 judges in the registrar lived in one. Of course, they had a rather isolated existence because, unlike, say, a judge going on the circuit in England or New Zealand, you couldn't fraternise with those lots of lawyers as you might otherwise do, because they had 41 pairs of eyes watching you, so they had to be heard on the whole time. But there were a bishop and revision, there were prison officers, court stenographers, registrars, etc. You name it, they were all there. And they all had to be fed and accommodated. They all needed, if they wanted to have some wine or other alcoholic beverage, they had to get a permit because of the 7th-day Emeritus regime. You had to get a permit to have alcohol on the island. Anyhow, at the same time as the trials were going on or about to commence on Pitcairn, another team from both prosecution and defence were at the Privy Council in London seeking special leave to appeal the Court of Appeal's judgment about Britain violating jurisdiction. They were given leave to appeal, but the Privy Council said, well, since you're all on the island, it's silly to cancel the trials. Go ahead, have the trials, see if you find them guilty or not, and then come back. So the trials went on in Pitcairn, and 6 of them were found guilty of various offences, but there were not convictions were not entered nor sentences imposed. We all went back, and they all went back to Pitcairn the next year because at that stage the defence had thought of further arguments, and these were much more substantial than the one about Britain not having jurisdiction. These arguments were that laws had not been properly promulgated, particularly the Sexual Offences Act of 1956. All that had been done was the government had made an ordinance saying all the laws of England enforced in 1970 apply to Pitcairn, full stop. So that was dealt with by the Supreme Court to New Zealand. At the end of it, they decided that there was nothing in this argument, so they then proceeded to convict and sentence each of the accused, and sentences ranged from 6 years imprisonment to community service, or 6 years of some of the more serious rapes, down to 2 or 3 years. The judges saying that the sentences were somewhat less than they might otherwise have been because of the unique situation in Pitcairn. That there was no appeal against those sentences. They then appealed to us in February of this year against those rulings, which we rejected, and they finally went to the Privy Council in July. Where 2 weeks had been set aside, but at the outset, Lord Hoffman presiding said he wasn't interested in the argument about Pitcairn not being a British colony because of the doctrine of active state. The government had on 3 occasions, first in the 1893 Order of Council extending the British Settlements Act to Pitcairn, and secondly in the 2 Orders of the Council creating the government of Pitcairn, 1952 and 1970, said that Pitcairn's a colony, and he said that based on authority, that was it. So that reduced the hearing time considerably to 2 days instead of 2 weeks, and they did hear an argument on the question of promulgation, which we'll come to in a moment. The feature of all the hearings has been the vast amount of paper that has been generated. Very serious and dedicated research was done into every document related to Pitcairn and its history, and extracts taken from the Public Record Office and other sources, Colonial Office, etc. And so we had, even the Court of Appeal hearing, we had volumes and volumes of these like folders, which were full of documents, all of which were extremely interesting, but not all of which were terribly relevant. And their lordships at the Privy Council had all this, but in electronic form as well as hard copy. So this shows you how they're coming up to speed. Now I shall now deal with the arguments which won't really deal with what was said in each different court, because all three courts really agreed on everything, except of course varying emphases. The first, of course, was the Act of State, because it was said that, well, this 1893 the Board of Council didn't apply because Pitcairn wasn't settled. It might have been ceded, but it wasn't settled. And the argument about it being ceded was regarded as a bit ridiculous. How does the population number 100 cede something? And it wasn't like, say, Malta, which was ceded after the Holy Wars, or Fiji, which was ceded by the chiefs in 1874. So Lord Hoffman said that that's out. However, there are three judgments in the Privy Council, and I sought you to read see if you can look at this tackle Privy Council UK judgments, and you should get a selection. The majority decision of Lord Hoffman, Stein and Lord Carswell was delivered by Lord Hoffman, but separate and very thoughtful judgments were delivered by Lord Wolfe and Lord Hope. All came to the same conclusion, but the latter two judgments I felt more happy with because they grappled with the issues that we had laboured long and hard over, and I felt them very satisfactory. But Lord, interestingly enough, for students of international law, Lord Wolfe did say that he was not necessarily going to accept that just because the government says so, that it's a British possession, that we should necessarily accept it. He said that many recent developments in relation to judicial review have demonstrated a greater willingness on the part of the courts to scrutinise the use by the Crown of prerogative powers. So it can't be taken for granted that the courts will accept that there is any action on the part of the Crown that is not open to any review by the courts of the proper foundation has to be shown. Of course, he said, well, the proper foundation is shown here, but interesting, the doctrine of Act of State is starting to wear a bit thin around the edges. Then there were a number of arguments which were all rejected pretty summarily in all three courts. Of course, knowing as we did that it was all going to the Privy Council, we did not treat that quite as summarily as the Privy Council did. We thought, well, you never know what the Privy Council might do, so we had to go into it pretty thoroughly. But first of all, the 1956 Sexual Offences Act was not an act of general application, and that I think has only to be stated to be seen not to be very, very valid. And that the 1970 order didn't include criminal law. I was at a loss to understand that one. And that it was not suitable for local circumstances, since when the offences occurred, they had been made right of appeal. And the Privy Council said, well, right of appeal is purely procedural, and as long as you haven't had a right of appeal by the time of convicted, then what are you worried about? But the real problem was the publication, because the 1956 Sexual Offences Act was never put on the board at the courthouse at Adamstown, which is the accepted way of advising the Pitcairn population of what's happened. In fact, probably the government, when he made that ordinance in 1970, didn't turn his mind particularly to the Sexual Offences Act. But the Privy Council said, well, only the ordinance has to be published. And as Lord Hope noted, the offence of rape as a statutory offence before the Sexual Offences Act was an act of 1861, which defined the act of rape and sexual and indecent assault made in crimes and imposed the maximum term of imprisonment. Whereas in common law, it was also also the same crimes, but no fixation on eternal penalty. So they act for the benefit of the accused. And so there was some discussion in the local council about prior to 1970 about English law applying, and that was well documented, and it was discussed in detail, and there was evidence called from local Pitcairners that they well knew that rape would be punished because it was a serious offence. And so, as a matter of fact, the Supreme Court found, and it wasn't challenged on appeal, that it was known that the offence of rape was punishable, and that it was contrary to the law. It was held that the Pitcairners did have some access to the various sources. They had the school teacher, they had the government representative, but they didn't need to know the previous sections, or the precise sections of the Act. In fact, I would imagine that most persons charged under the Sexual Offences Act don't know the precise wording of the Act. But it was held that even in a tiny and remote community where there weren't many resources, even though justice requires that the law be known, that it was known that rape and indecent assault were serious matters, and this was a finding of fact. So it was held that although there was no copy of English laws on Ireland, in fact, somebody sent in 1997 a copy of Hornsby's Laws of England and the Statutes of Vicarage, maybe both. But I think they're still gathering dust in the current Pitcairn court, I was told. Then, so having decided that, they then turned their mind to other arguments about abuse of process. There were a whole lot of arguments about abuse of process. None of them cumulatively really added up to much. Abuse of process occurs when there's an affront to justice, so that the person should not be prosecuted. And the court has to weigh in exercise of discretion whether the public interest is better served by prosecuting the person or by not encouraging the affront to justice. And it was held there was no prejudice to these people, and that there was no affront to justice. The various causes, the various heads of this particular lack of due process argument was the lack of the English police presence, the incorporation of Pitcairn into Pitcairn or of New Zealand rather than English penal legislation and other machinery of justice, the failure of the government to appoint English judges and prosecutors, so the principle is, and the late institution of enforcement or other machinery of justice. In other words, sure, it took a long time for all these things to be implemented, set up the courts and logistics, but it had all been in place at the time for these people in the first question, then they would have saved all this time. But the Privy Council didn't think much of that. And that was a question of delay. And so some of these arguments were pretty thin, and the Privy Council, we virtually said so, the rather guarded way, and the Privy Council accepted what we said. So the result is that all appeals by all six appellants have been dismissed. Those who are sentenced to imprisonment will now commence to serve their term in the prison on Pitcairn Island, which is the best accommodation in the islands. It having recently been built by the very accused themselves at the expense of the British taxpayer. They're being paid somewhat in excess of what they might expect to earn on Pitcairn Islands. It's not much employment, but they have the population of 49. So they will be going there. It's the only place in the island with plumbing up top. So they all commenced their return. 7 prison officers from New Zealand have accepted tours of duty to go and service the prison, again at the expense of the British taxpayer. And so that's what's going to happen. Some of them are serving community service, and I happened to be an email from a magistrate maybe yesterday, or another matter, but he mentioned that in his role as magistrate he was going to hear an application for home detention by one of them. So that's one of the sort of raft of more sophisticated penal statutes which have been incorporated into Pitcairn law. But just to wind up, what has been the result of all this? Well, the effects have been pretty devastating for the community, very divisive. There are those who staunchly maintain that these people should never have been prosecuted. There are equally a number of many who say, well, of course, they had to be, because this abuse had to be stamped out, and this was the only way to do it. And resettlement is not an option. I will want to stay there, because the Foreign Office has the bogey of the Chagos Islanders in the back of its mind. About them in the middle of the Indian Ocean, Diego Garcia, who were shipped off in the 1960s by the Harriers. The government sent to Mauritius because the Americans wanted Diego Garcia as the military base in this case. So take off to drop bombs on Iraq. So didn't want to repeat of that. So they're there. Justice has been an immense cost, not only financial, but a huge effort of all involved. At last, something is happening in Pitcairn. The first sealed road is happening. It's the steep hill from where the boats land up to the main settlement, about a mile, called the Hill of Difficulty, which has been very muddy for years, and now it's at last been sealed. What will happen to Pitcairn, I don't know, because the possibility of eco-tourism could only happen if there were flights. There was only if it is debatable whether an airstrip to take a plane was to hold about 20 people could fly from Tahiti, 300 miles away from the edge of Tahiti. But that would be the only plane they would get. If that happened, then there could be eco-tourism, particularly to Henderson Island, which is, as I say, is a wildlife reserve. But what benefits there could be, I don't know. It's all terribly sad, and all these people, as I say, are very divided, because some of the judges told me that some were very badly disposed towards it, and some were well disposed towards it. Interestingly, the women of Pitcairn seem to be in two camps. One says they should have been prosecuted, and the other says they should have. But there it is. Things will shake down, I've no doubt. But it's been an interesting exercise for those involved, and I don't imagine it will be repeated for a long time. So I think I've just got my time to leave it, Mr. Chairman, but I have a few minutes if anyone wishes to ask questions.
Very much. So, fascinating story. It struck me that one revenue earning opportunity that has now been firmly closed off is sex tourism. But what does anyone want as well?
I suppose I want to ask a factual question rather than a legal question. I mean, is it known whether these deviant sexual practices had been going on for hundreds of years? And you said the first offence was 1969, but I mean, was this something that might have been going on for 100 years or more prior to that? And was part of the old culture? Was it something that had broken out and developed in the last 30, 40 years?
Well, it is suspected that it probably has been going on longer than that, but nobody knows. Nobody can say for sure, but it's suspected that it had been. But 1969 was quite a long way back for a historic offence. But could have been, I don't know.
Can you tell us a little more about the culture and the history of the island and everything? Missed that.
What do they do?
Yes, exactly.
They, in the days when the ships went from Auckland to Panama, passenger ships, which I went in once, I didn't go that way. They used to stop off Pitcairn, and if the weather was fine, people went aboard and they ashore, and they sold them their handicraft. They were very good at carving walking sticks, that sort of thing. Also, weaving or sewing, women did that. Postage stamps, but as I say, they're fairly self-sufficient because the island is fertile. There were introduced animals, goats particularly, and other animals, so they do have some meat. I think even though the coastline is pretty rugged, there's always fish. So, but what they do all day, they do farming, I suppose, horticulture really. And they do go to church, I think. They put quite a lot. They have a resident Seventh-day pastor.
So how many adult males are there on the island?
No, not sure. I think about 20.
And you think only 6 of them were?
Sorry?
And only 6 of them were charged?
Yes. I don't know. That's what I was told. That's what comes out of the judgment. I think it may be there are fewer. Some are quite elderly. Not too many young people there now. They normally go offshore to have babies now. They didn't used to, but they do now. And because there's no medical nursing service on the island at all.
I just wondered if you think the imposition of a sort of criminal justice, or I don't know if the ordinances, I suppose it also apply to civil cases, but do you think that would change the way law is used by the Pitcairn Islanders? Like, is there any indication that now that they've seen that the trial can go ahead in this way, that they would try to bring suits themselves? Or
well, they are fairly law-abiding. They've had this system of this lot of ordinances for many years. So the thing you can hear me. They've had the system of ordinances for many years, including minor penalties for theft and things like that. Also, it's an offence to call out ship ho when there isn't a ship there. So they've had this, and I think the magistrates, the sort of island magistrates' powers will be strengthened a bit. And I was talking to the Chief Justice a month or so ago, and said he was just going up there for a civil case. They haven't got any civil procedure, any rules of court or anything like that, but it was basically a boundary dispute, and I think he kind of mediated. But they are obviously more aware of legal rights, systems and legal rights. Yes.
sorry, how many of them are in prison?
6. Well, I think one or possibly 2, I'm not sure, were on probation and doing community service. So I think it's maybe 5. I think it's probably 5.
Why was it so important to hold the trials on the island itself? You said before that you could use a legal fiction to actually make a different part of the country kind of part of that country, like in New Zealand, the courts were used that way.
Well, I think it was a bit local feeling. These are local crimes, local people, and justice must be done in the community. The complainants, of course, were back in Auckland, and they gave evidence through video links. think it was almost all offshore. See, after Constable Gail Cox uncovered every woman who lived in Pitcairn between 1980 and 2000 was interviewed. Most of them were in New Zealand or Australia, and that's how the raft of charges came. Most of the complaints were not on Pitcairn, and almost all were not on Pitcairn, but they come to Pitcairn to give evidence, and their evidence was relayed and cross-examined by counsel up there through the video.
If I can ask another question, and if I understand it correctly, New Zealand legislation is required to deem the New Zealand court part of Pitcairn.
Yes.
But as far as the UK was concerned, the whole edifice was created under the Royal
Yes, there's no reciprocal or sort of mirror image legislation in England, but the treaty is a schedule to the New Zealand Act. Pitcairn Trials Act 2002. But no, it wasn't necessary.
And, sorry, a final question for me. Have we any idea what prompted the police, the Kent Constabulary, to be sent out? Were there suspicions that there might be something awry?
Yes.
Or were they just sending them out because Pitcairn has deserved a copy of the beat?
No, I don't know, it's not revealed, but I think there were suspicions.
What's the construction like on the island? Is it all timber shacks?
I don't know. I haven't been there. I didn't go there myself. I'm too old to be clambering down the side of the creek. I think it's reasonably substantial because they do get some pretty bad weather, so it has to withstand that.
I was wondering how this case might compare to the way Australia dealt with the arranged marriages in Aboriginal communities in Australia, and how Australia's the Australian government.
I'm not any expert on Aboriginal rights in Australia, but I don't really think there's anything comparable. But I know that, all I know is that there have been, in recent months, allegations of widespread sexual abuse against certain Aboriginal communities. I don't know what's happening.
If there are no other questions, it's time on your behalf. Thanks, Ian, very much for a fascinating account of history, legal development, and the trial process in a situation where people were having to make it up more or less as they went along. It's a lesson for those of us who are vaguely attached to the idea that law is something predictable and settled, that sometimes only a very minimum amount needs to be predictable and settled, and you can still produce the results at the end. Thank you very much. Thank you very much for taking the time to come and talk to us. Ian is a visiting scholar at Wolfson College at the moment. Is around for a while, and we're very happy that you're able to share our facilities and contribute to our work. It's been a fascinating